everyone. Welcome to the Lawyer Lifter podcast, or Mel's Minutes, where I talk about lifting, life, and business. Hi, everyone. Welcome to the newest episode of Lawyer Lifter podcast. And actually, it's going to be a series of the same topic, but different issues. This first episode, I am joined by one of my staff members here at Uplift Law, Arianna Dela Cruz, who sits as my executive assistant, and she's also a legal assistant here at the firm. And she's going to tell you what she does.
Hi, everyone. I've been on the podcast before, but back when we were still going through Mel's pregnancy journey. Now we have kind of moved on from that, and I am a legal assistant. I also sit as Mel's personal assistant, and yeah.
So what has happened lately actually has happened or has been in the making since I started practicing. The trial, it's about a trial that is actually still ongoing. It's called Shulman v. Kaplan et al. Et al. Is the phrase which means other parties. So in order to tell this story, I have to take you back to the origin because I've been practicing for a long time, I think 14 years. And I distinctly remember going through my practice when I was with law firms before Uplift was born, watching in the shadows these partners and these trial attorneys do the thing that I wanted to do. That was probably one of the pivotal moments where I knew that I wanted to be more than just some associate in a law firm or just some, minion. I wanted to do what the big boys were doing, which is do trials in business litigation. So the first things first, you should know that everybody talks about trials. Trials are very different per practice. So there's obviously criminal trials and then everything else. You can have trials in like small claims, like very small things. You can have trials in immigration, family, whatever. But typically when people look at movies or TV shows, let me give you one that maybe so many of you can compare to would be Suits. In Suits, they deal with my practice, which is business law, business litigation. And it seems like in Suits, trial just happens. In my practice, trial rarely happens. And then let's make a distinction. When we talk about a jury trial, now that really doesn't happen. And the biggest reason jury trials in business litigation don't happen is because it is ultra expensive, and 99% of trials don't happen because people settle out because it's so expensive. And it's kind of like a game of chicken when it comes to this practice, because each party, plaintiff and defendant, they see which side's going to fold first. And I'm also going to it's funny because this podcast is also going to give you like a speed rocket lesson, law school lesson 101 in business litigation, because I can't tell you the story unless I educate you on, the life of a lawsuit. And so anyway, lawsuits typically settle. And because, as I said, it takes a power of money to get to that point, because what you're dealing with in terms of trial preparation, clients are paying the lawyers to sit there, not just in court for the time that they're doing the trial, but also after. What TV and movies don't depict is it's a marathon. It's like a time warp, because trial starts almost like at the beginning or the birth of any lawsuit. And then once you're in trial, if you ever, when you get to that point and nobody settles, nobody like successfully plays the chicken game correctly, it is an all day, all night, every day, basically until you die or until you get to the end result. And everybody's wondering like, oh, so did you go to trial? Is it done? And we'll get to, that's probably another episode or two later. But as we sit here today, the Shulman trial is not yet done. And so I started with the origin story. I've always looked at these men that when I used to be in these law firms, and I always wished like, wow, like I would love, instead of doing the grunt work to prepare for trial, I would love to sit at counsel table and have a speaking part, because I can speak, because I can think on my feet, because I know the issues, and I never got that chance. In fact, a lot of lawyers in my practice will tell you that it's very rare to actually, yeah, I told you it's very rare to see yourself into a jury trial. And so many lawyers don't even do a trial until very late in their career. For me, as I told you, I've been practicing for 14 years, and I had never led a trial until October of 2024. And it's so funny because even though I told you in the very beginning, in the origin story, I always prayed for that opportunity because I felt very marginalized and never given an opportunity. I've never been in a situation where I was so deathly scared and so emotional than in the capacity of leading the Uplift Law team and the clients into battle, into trial. So Arianna is here because we have, with the Shulman trial, that case, if anybody can believe it, actually has been going on for 6 years. Uplift Law, though, this is one of Uplift Law's largest clients, Vertical Companies. Actually, Vertical Companies is the DBA of the parent company, which is Medical Investor Holdings, LLC, or MIH. And Uplift Law did not take over all of MIH's legal department, both the general counsel side and the litigation side, until 2021. And the Shulman Shulman lawsuit, was handled by my predecessors. So counsel that represented MIH, DBA, Vertical Companies, like before. And when of all the things that we inherited the Shulman lawsuit. And my client, Vertical, has the fortune and misfortune of being so riddled with litigation. And I say fortune because really, I say this to a lot of my business clients, mo money, mo problems, right? There's no, in business, like you start off very small, but an indicator of your expansion or openness or success is in the growth. And you can't help but in that growth invite liabilities or, enemies, right? So the thing about Vertical and the thing about the Shulman trial, which that's why it's so near and dear to my heart, is that it's such an example to all the business clients and all the businesses of the trips and tribulations and trials and the do's and the do not do of like a business. So the Shulman lawsuit, let me tell you what that's about. It is about two people, CEO Todd Kaplan and Francine Shulman, that found each other, and they decided to join up in a joint venture in a time where California was just legalizing recreational cannabis. And if you can think about, that would have been circa 2016, 2017. And if you can think about what that felt like at the time, that was like the gold rush. And everybody thought that, okay, California is legalizing recreational cannabis. This is going to be like just for sure easier money. Like, let's all capitalize on this. And so Todd Kaplan, the CEO of Vertical, already had a very great business background. He had been in business, an entrepreneur for 30 plus years, and had made his mark. And Vertical Companies is so named because it had an idea of vertically integrating in the cannabis market. So seed to sale, grow, manufacture, distribute, sell, outdoor, indoor, legal cannabis at its most sophisticated method in utilizing technology to make the most premium, luxurious cannabis out there. And so that's Vertical Companies. Vertical Companies is made up of about, I want to say, 200 to 300 shareholders. And at one point, Todd Kaplan raised $64 million to Vertical Companies back in the day, back when California had legalized recreational cannabis. And so Todd and company were looking at various opportunities to grow. And the indoor facility, honestly, the best in the state of California, Vertical has in Needles, California. And at the time, I said around 2016, 2017, Vertical was looking at outdoor grows or outdoor property in order to grow. And that's how Ms. Shulman came into the picture. You know how everybody just, it's like who you know, or that whole, like, what did they say? You're 6 people apart, or like, basically I have made out with Brad Pitt because like so-and-so has made out, like that,
It's
that
all
type
about
of
connections.
It's all about connections. And so Todd wasn't looking for Francine Shulman, but through one of his directors of branding, she knew the wife of the son of Franny, and the word got out like, hey, she has premium property in Santa Barbara County, and you, Todd, have this like team of experts. So let's join forces. Let's start a relationship. And I know anybody who's tuned in and or has seen the reels, like, I mean, we're just kind of stirring the pot. We're just forming the makings of a really juicy story or a really juicy business. So Franny and Todd got together, and in an exciting time where both parties thought, wow, let's make some money. And they just acted too fast, right? We're talking about some sophisticated business people, and even in the most sophisticated business people, things can go awry. Contracts weren't as great as they should have been. Things were said that probably shouldn't have been said. Misunderstandings, like just miscommunications. So all of that, all of the relationship and the drama and the people and the story. I mean, we're talking about a story that includes felons, like sex, drugs, millions and millions of dollars that is the Shulman trial, without a doubt. And I can speak very freely about it because it's actually, I have the luxury of saying it is in the public record. So, and none of what I'm saying isn't out there for you to click and to find out about. So let's take it back. So the lawsuit was against Todd and C-suite. When I say C-suite, I'm talking about the chief operating officer, chief financial officer, chief technology officer, director of brands, vice president of brands. So basically all of the top people at vertical companies and the entity and Todd were sued. That lawsuit, by the time it hit my desk in 2021 and belonged to Uplift as counsel, was about 100 plus pages, demanding $165 million. And I looked at this lawsuit and I thought, holy shit, like this was every single business litigation issue that you could think about. This included fraud. This included elder financial abuse, breach of contract, all conversion, which is the civil word for theft, like just everything. And why do I say elder abuse? Like some people kind of don't understand, because you see it on TV, you see it in movies, like it's so sexy, but the people that are suing each other are usually depicted as being very young. Todd and Franny were later in their life, a different generation. So that might surprise people, but it's true. So you can be 65 and older and still be killing it, by the way, people, in your business savviness and in business choices. So I know with this generation, especially the clientele of Uplift Law, you're used to kind of seeing a younger, but we actually very much are lawyers for the more seasoned business people as well. But the seasoned business people that are very much young in their business mindset and young in their heart, and also into industries like cannabis. So Francine had struck this relationship with Todd and company when she was under the law an elder, so 65 and older. So one of her causes of actions, which means one of her laws that she claims has been violated, was financial elder abuse. So anyway, Uplift Law inherited this lawsuit and also the clients that were sued. So the defendants were the entire C-suite and the company itself. So we were talking about Todd's also family. We're talking about, even though I'm talking about millions of dollars, at the end of the day, this was still a small business. And that's kind of why you hear it all the time from me, that don't be fooled by the name small business. Small business is seriously anybody who's not Amazon. Vertical is still considered a small business, and it's family like run too. So part of the people, some of the people that were sued were actually Todd's own family. His brother, who is the chief technology officer, his son, who doesn't have any affiliation with Vertical now, but at the time of the lawsuit, he was working as part of the venture with Francine. His niece, who was also assisting on the legal side, she's a lawyer. And she was sued as well as the former general counsel of Vertical. So one of my own predecessors was sued. So I say this too as a, like everybody thinks like, oh, it's so cool when you have a business and you're an officer or some kind of like higher ranked person. Like that's so cool. But understand that when you sit as someone in charge, well, you can be sued because you're in charge. And and that's exactly what happened here. And so when this lawsuit hit my desk and I reviewed it, I immediately thought to myself, shit, this is a lawsuit that's actually going to go to trial. It on either side, I kid you not, the attorney's fees have been upwards to $500,000 to $1 million. And ongoing, because I told you we're not done. And so I have never known in my entire practice a lawsuit in which we were so busy, even before it became completely real that we were going to go to trial. So I inherited the Shulman lawsuit in 2021. We went to trial in just what even day is it? Because in October, the beginning of October. And this lawsuit has seen an insane amount of it's like the example to any law student, any young lawyer of beginning to end. We were constantly in court. There were constant like motions, discovery issues. I think we took, or the other side took about 20 depositions, all on camera. We took depositions. There was, it was crazy. We had big motions that were done, like motions for summary judgment. We also filed a cross suit. So when I thought to myself, this isn't going to settle, this is definitely going to trial, that was because the parties were so far apart at the time. One wanted still millions of dollars and the other like wasn't seeing and didn't even have the capacity to settle out for the millions of dollars. And when we talk about fighting, when we talk about cases that settle, it's because you fight so much where one party gets the momentum to force the other party to, make a calculated decision. Do you want to for sure settle and get for sure money and avoid the risk? Because there's a serious risk of losing and a serious risk of not getting any money, because a jury trial is like going to Vegas and gambling without the drinks, because you are putting your entire life, your livelihood, those of yourself, the company, and others in the hands of strangers. Part of the reason, too, this lawsuit was insanely expensive leading up, we're not even talking about what happened at trial, was because we had to find experts. And experts in the field are, you would think that they actually like created their expertise, because I think one of our experts is Ms. Jean Shaw. She is an expert in professional conduct, because as I don't know if I mentioned this, but two of the people that were sued were lawyers, and they were sued because they were lawyers. The allegations against our clients, the two lawyers, was that they engaged in a conflict of interest, that they defrauded Ms. Shulman, and some serious like taking away licenses type thing. And so we needed to find an expert in the California rules of professional conduct who could opine and talk to a jury about why our clients, didn't do the things that the other side was doing. And so that expert, Ms. Cha, I think she's $1,500 an hour. And her retainer itself was like $25,000. That was one expert. Let me tell you, my client's vertical had 4 experts. So we needed Ms. Cha, who would who would exonerate or corroborate our theory of the case as it pertained to how our clients didn't engage in ethical bad things. And I say that, I've been saying this here and there, oh, I'm a badass, blah, blah, blah. But I don't think I really, really owned the crown or owned that title until the Shulman trial, because it's one thing to defend one client, okay, like one business. It's another thing to do that with what? We had 13. We had 13. We had 13 clients that we were defending because, as I said, they sued the companies and they sued C-suite. So imagine the drama of having 13 clients and then 13 separate issues that they were sued like in their individual capacities, in their capacities as they were working for vertical. So everybody had different issues. So which led, and people are thinking like, how is it that like the client had $500,000 to $1 million worth of attorney's fees? Because there were so many fucking clients that were sued. And the costs just kept going up and up. Like, how do we build a case where we have any chance of winning? And think about it, like these people, each person was so fucking scared. And so, all of you who are so excited, right, to be, I'm a CEO or I'm a secretary, I'm a president. And it's like, understand that with that comes extreme responsibility and liability. So we have these individuals, not just talking about the CEO, who were faced with a $165 million lawsuit. It was so emotional for each one of these clients. And it was extremely taxing for Uplift Law as we were getting closer and closer to the apocalypse, which was, we are like full speed going to have to do a fucking trial. Who is going to do this trial? And then I looked in the mirror and it was like, fuck, that's me. like what the fuck? So I told you that we had 4 experts. Okay, so I talked about Ms. Cha. Then we needed a kind of like a very nuanced expert. We needed an expert in cannabis. And it's like, well, I mean, thinking about it, like, who the fuck is an expert in cannabis? Like that legitimate, we would laugh about this because that's legitimately like anybody. It's not a thing. Like it could be someone who's been smoking for like 10 years, right? Like, or someone who's been in the black market. Like we needed someone to speak to the fact that my clients actually knew how to grow and knew how to create a cannabis outdoor operations in the best way possible at the time. So we found Mr. Perkins, who is fucking crazy. Like we need to get like a picture of him so you guys can see. Or like during his deposition, the other side took his deposition. That's another thing I'm going to teach you guys about expert depositions. Mr. David Perkins, and he has been just such a character, because I swear to God, and he's not going to ding me for this because it's fucking true. He has dreads that are literally like my body length. Okay. Like I'm 4'10". So basically they're 4 feet tall. They're 4 feet in length. But that doesn't take away from the fact that he's articulate, that he can speak to, just the parts of a cannabis plant and what parts are valuable and what can be used for what. So looks can be deceiving, because Perkins just was able to speak to that. And out of the experts, he was the cheapest. I think like 375 an hour, and then like a $5,000 retainer. And then we had a cannabis regulatory expert. So if you didn't know, California is still so volatile in the market because the laws changed. They change, or they were crazy at the time of legalization. On the state level. So understand that when we talk about cannabis, there's state laws, county laws, and then you can have local laws too. So we needed someone who could speak to the fact that Vertical was following the rules and regulations at the time. That was Mr. Damian Nasiri, who is also a lawyer. And he was also expensive. And I mean, when you're dealing with like tens and millions of dollars, what's another fucking like 10,000 here, 5,000 here? Like, it's crazy. So he was, expensive as well. And so that's the third expert. Now, let me tell you, you thought maybe Gene Chaw was expensive. No. Let me tell you, the most expensive expert who was absolutely necessary. And everybody's thinking like, Mel, did you really need all of these experts? I don't like to spend client money like water. No, that's not even clients listening to this, like they know that. But the most expensive one was Mr. William Wolf. And he legit is goals. Okay. Like this man has an impressive CV. He's like ancient, but he's so sharp. And he was the forensic accountant, CPA. We would have meetings with him and he'd be like, oh, I'm just like on my yacht, like steering it into Catalina, and it's like, oh, I'm not available because I'm taking my yacht to, I don't know, like Newport or whatever. But so important to this case because of the millions of dollars involved between the plaintiffs and defendants, because one of the allegations was that my clients defrauded monetarily Ms. Shulman. So both sides, they had their own forensic accountant, needed to unwind the numbers. And guess what? We're lawyers. Like, what the hell do we know about numbers? So of course we needed someone who could speak that language and tell us like where the money at, and so that was Mr. Wolf, and his bill ended up being $100,000. Easy.
Absolutely needed too.
Absolutely needed, because like, what is a jury gonna understand about like what is net income? Like a lot of people, maybe to you guys that we're talking about, oh, like, yeah, I know what net income is, but like That's not just a common term. So a lot of the need for experts is to take something insanely complicated and make it so that it's not just the lawyers talking. It's not just the clients talking. It's like a third party who can take the most complicated things and put credibility behind it. So, I'm going to have to leave you on a cliffhanger because that is part 1 of God, part 10, we'll say, of Shulman. And we haven't even scratched the surface. And I still owe you guys a bunch of law school business litigation 101 lessons. So tune in next time to the Lawyer Lifter Abroad podcast as we discuss more of the Shulman lawsuit. And that wraps up the Lawyer Lifter podcast, aka Mel's Minutes. Catch this episode on Apple or Spotify. See you next time.